Now, if I told you that in 2014, the Massachusetts legislature passed a law that would allow a rapist to obtain visitation rights for his victim's child, you'd say fake news, right? I wish. In fact, the 2014 Domestic Violence Act gave probate court judges the power to allow visitation by such criminals if it was, quote, in the best interest of the child. Now, I'm no family law expert, but I am a father. And I've thought long and hard about this and haven't been able to come up with even one scenario where such an award would be in the interests of a child. Here's the practical impact. A 14-year-old woman was raped by a 20-year-old man, Jaime Melendez. He eventually pled guilty and was sentenced to 16 years of probation. He was also required to pay $110 weekly in child support. 5 years later, he filed for visitation rights under that statute I just mentioned. And not surprisingly, his victim, represented by Wendy Murphy, director of the Women and Child's Advocacy Project at New England Law School, opposed the motion and is appealing to the Supreme Judicial Court to throw out the original ruling that left the door open for the rapist to see his child. Murphy's position is that this is not about visitation, but about leverage to reduce or eliminate the child support. Now, there's several problems here. One, the lack of transparency of Beacon Hill's original action. I can't find any record of a public hearing on or notice of this provision, which I think a lot of people would have cared a lot about. And two, the pain caused a rape victim who is forced to return to court again and again to relive the trauma while fighting against her rapist's claim he has a right to see the child. As we sought to get to the bottom of this today, one involved party suggested the provision was intended for, say, a 16-year-old and a 15-year-old, technically statutory rape, but not as egregious as the case above, which they would argue was an unintended consequence of the law. Well, if that's the case, why was a bill filed last year by Senator Dan Wolf to prevent an adult rapist from gaining visitation rights not passed by the legislature? Listen. When this child is an adult, if he or she wants to see the rapist, that's up to her. But for now, it's clear that when passing legislation concerning the so-called best interest of the child, Beacon Hill cared nothing of the best interest of any of the children who would be abused by a rapist not once, but over and over again. What do you think? Email us, tweet us, share your thoughts.